initiative of students, Law School of Anyang Normal University exploit the pedagogy of initiative litigation cases. Its theoretical basis is the legalization of social issues, that is, social issues into legal ones. The measures are to encourage students to create cases and handle them under the guidance of the teachers, so to realize learning by doing. This method includes the following two basic contents. Firstly, students can turn the relevant civil disputes into civil litigation cases. Although students live on campus, they have to carry out many civil acts every day as social people. The most common ones are purchase of the goods, acceptance of the service, consumption, and working in the spare time. In the process of engaging in these behaviors, sometimes it's inevitable to have disputes. Students majoring in law should not take such disputes for granted, but take rights seriously with professional eyes. If it's difficult to solve the disputes or fails to achieve the expected effect, it's necessary to bring a civil lawsuit to the People Court or an arbitration to the Arbitration Commission. Pedagogy of initiative litigation cases not only make students familiar with the process of civil litigations or arbitration, but also exerts their ability of legal practice. What's more, they experience the complex feelings of the parties themselves. The experience of such parties brings students much more than a few teaching lessons in the classroom. This experience will urge them to stand on the parties' side to deal with legal practice, which will help them to be more cautious and conscientious after entering the legal profession. Secondly, students can file administrative litigation in accordance with the right of citizen supervision empowered by the Constitution of the People's Republic of China. Article 41 of the Constitution stipulates that citizens have the right to appeal, sue, and report to the relevant state organs for any illegal and derelict act committed by state organs and state functionaries. If a citizen is not satisfied with the decision of the administrative organ, he may file an administrative lawsuit by law. Xi Mingqiang versus Government Information Disclosure of the Ministry of the Public Security of the People's Republic of China, and Zhang Hongjun versus Rugao Price Bureau of Jiangsu Province, published by the Supreme People's Court, can serve as examples for students to file administrative litigation by authorized supervision right. To fulfill the right of the citizens' supervision by litigation is not only the external manifestation of the citizen consciousness of active law-abiding spirit, but also an important way to cultivate the citizen consciousness, which is an important internal driving force in the process of China's rule of law and of great significance to comprehensively promote the rule of law. It's a great pity that the current legal education neglects to educate and guide students in this aspect. However, the problem of this method is that, first of all, participating students will not be many of them. Otherwise, it will lead to excessive litigation and increase the pressure of the courts. Secondly, because students are undergraduates and have no occupation qualifications, students will hardly, because the current laws in Chinese mainland are limited to the agents of their close relatives, which will reduce many real cases. To find out the limit, I investigated several judges. I asked the judges, can civil and administrative cases be entrusted to ordinary citizens? Ordinary citizen means no lawyer's qualification certificate. Judges answered, if the principal is a company, the staff of the company can act as the agent, but they shall submit the corresponding proof. If a natural person is a close relative, he or she
colleagues, I think sadly we've lost the connection with Professor Lee once more. That's really unfortunate. We'll give it a few minutes to see if we're able to reconnect with Professor Lee, and I'm sure our supporting administrators are busy trying to make a connection so as to be able to hear the end of Professor Lee's paper. In the meantime, I'm going to share with you some of the comments that are coming in on our chat, where Ian is reflecting himself on some of the feedback given to his paper and how he'll be looking to develop this further. The suggestion that Michael Lower made at the end, which I shared with you earlier, about the interviewing of students, it's my thinking that perhaps this gives another opportunity to develop and even assess the students' oral communication skills. I wonder if any other colleagues have any further questions to pose to Ian or to Michael on their papers, or even the synergy between both papers, since it's very clearly quite a lot of connectivity between the ideas explored there. For my part, I think there's quite a lot that you can be thinking about in this regard, as I say, about the learning community, because we are all, I guess, working towards developing things to go online for the new term, however soon or however late that is going to be in the year for you in your own countries. For us at Chester, it starts in September, and in terms of this kind of practical element of our students' learning, all our students undertake a work-based learning model during their second year of their degree, whereby they take a 5-week placement, so they can take that with any kind of employer. Many of them do take it with solicitors and barristers. I think we've managed to reconnect with Professor Lee now.
Yeah. Can you hear me? Can you hear me?
We can hear you, but it is quite a poor line.
Yeah. Sorry. But
perhaps we can ask you to wrap up towards your conclusions, so that we can make the most of the connection as we have it now.
What? Beg your pardon?
Could you work towards your conclusions so that we can hear the end of your paper?
Okay, now. Yes. Okay, now I can end my paper. Oh, okay, now in a word, the pedagogy of initiative litigation cases overcomes the shortage of real cases in the above 3 teaching methods. It's a supplement to the above 3 teaching methods. It can improve students' ability to find and solve cases, strengthen professional ethics, literacy, education, and better cultivate students' sense of social responsibility and ownership. Okay, that's the end of my speech. Thank you very much.
Thank you ever so much, and you can breathe now.
Okay, thank you. Thank you.
It's so unfortunate that we suffered those connection problem, but I actually think the connection is far better now. So if anybody has any questions, please do get them into us on the chat. I think it's likely that we've missed quite a lot of substance of your paper as we've lost out as we've gone along. My question to you would be in relation to the cohort that you've done this with, a bit of context about who were the students that you conducted this pedagogy with. So what year of studies were they?
Okay, my teaching students, undergraduate students, yeah.
So, what year group was it? Were they in their first year, second year?
Yeah, the second year. Now the third year. Okay. After they mastering the basic legal knowledge.
Right, okay, so there was some kind of underpinning legal knowledge kind of from a more theoretical perspective to begin with, and you were building on that to make it more practical. Are you able to hear us?
Yes.
So they had already studied some theory before this?
Theory.
So they were able to put into practice what they had learned on their studies so far?
Yeah. They have learned the civil law, constitution law, and administrative law. After they Okay, can you hear me? Okay, I think the internet is
we missed out the connection again there. Could you repeat your response, please? We lost the connection with your answer. Could you just repeat your answer, please?
Okay. I will learn civil law, administrative law, and constitutional law. I can lead them. I can guide them to the initiative litigation cases.
Excellent. Thank you.